Aloha, everyone. Marcus Landsberg. Earlier today or yesterday, I haven't got to sleep yet. You can tell I was partying so hard. They held the hearing where Matthew Barhoma and Jose Baez were finally heard by Judge Herriford as to if Tory Lanez gets a new trial. Let's dive right into it. I didn't dress up. I apologize. I didn't comb my hair. I hope you don't mind. My law knowledge doesn't change and if I'm wearing nice shoes or if I'm wearing flip-flops. As always, I'm going to call it right down the middle. I'm going to tell you what's good, what's bad, what's good for Tory or bad for Tory. I don't have a dog in this fight. So whatever I think is correct, I'm going to tell you because you're the one I want to know to be able to talk about this intelligently if we do, or you have to talk about this at some point, get to talk about this, I should say, at some point in the future. The roadmap is this. This is what I want to discuss. Let's discuss the errors that the attorneys argued, discuss why the judge decided the way that he did, why if he should have changed his mind. And then let me tell you, most importantly, if what was said that wasn't with words, if the judge or attorney said or did certain things that as a lawyer we either know or we get the message that they should know, that words they use or actions they take may mean different things than what it means behind the story behind the story, so to speak. This is the behind the courtroom. That's what I'm trying to explain to you. From what we know, I don't have any inside tips. I don't have any inside information. But because of that, I could give you the whole thing. I don't have anybody to protect in a case like this. Let's start with this. Anytime the judge gives the defense unlimited time to make their points, the judge has already made two independent decisions before the case started. Number one, they know this case is getting appealed. It wasn't a mystery in this case, but they know what's happening here. Number two, that the defense is going to lose the motion. That's been decided if they give the defense an unlimited amount of time. Why, if the judge knows they're going to lose, is he not running to lunch early? And why does he let them talk forever? The purpose behind this is this in the judge's mind, that it's easier for a defendant to win on appeal if, or show bias from the judge, which is one of the things they're arguing, if the defense attorney is not allowed enough time to speak. On appeal, an attorney can say, I would have argued X point, but I couldn't because I was not allowed the time to argue it. By allowing them to speak and then reconfirming when they're finished and then shutting down the attorney, what they're doing is shutting down the attorney on appeal from arguing something they either haven't thought of or haven't discovered yet by the time they're in court. The purpose of this motion is not to win. Yes, they would have loved to have won this motion in court. I don't want to pretend that that's not the dream goal. But that's not the goal that they're really that's the goal they're shooting for, but it's not the one they know they're going to get. So they have to aim for the intermediate goals, what you're doing. What they're trying to do is make sure they put all their arguments down at the lower court level. The whole goal is to make sure any argument you want to raise to the appeal, anything you want to appeal, you have to let the trial judge get first crack at saying why you're wrong. Why? The reason why you have to do that is because the purpose of an appeal is not to say any independent evidence. It's not to look at any new arguments, anything in that nature. The only thing they do is look at the judge and say, based on what was presented to the judge, did we make the right decisions here? Did that judge make the right decision, or should he have decided a different way? The second thing to decide is, had he decided a different way, would that have affected the outcome? So the question here, why are they putting all this on the record now, is to make sure it's there clearly, to argue later and make sure the judge has the first crack to say why they're wrong. So later they can say, here's why the judge was wrong when he said my argument was wrong. We know there's an appeal, and we know the appeal is done by the people who not actually did the trial in this case. So I just told you the purpose of the motion to win. I jumped ahead on my points. The purpose of the motion to win, and even if they can't do that, the purpose is to get all these arguments on record. But the standard to win at the appeals court is easier for any argument made at the lower court level. This is important to remember. If you don't make the argument at the lower court level, one, the standard is always higher. Two, the higher court in many jurisdictions and in many arguments can decide that you've given up the right to make that argument because you did not make it in front of the trial judge. If you did not make it and you've given it up, you may have the greatest argument in the world, but many judges won't hear it. The famous quote from Scalia, which is a horrible quote, by the way, but it's famous from him, that said, I think it was something along the lines of, actual innocence is not a reason to appeal the case. I might have misquoted him, but look that up directly. It's horrible, but it's the way the law system runs in our country. Okay, so here's what I expect happened in this particular case. I expect Barhoma and Baez, Tory's new attorneys, did, and I may be wrong, but this is my prediction. I think they decided what they wanted to argue on appeal. They decided what their best appeal issues were done already. Probably wrote 80 to 90% of the appeal already, got it all in place, and then converted the appeal they were already going to write or already liked into the motion for a new trial. By doing that, you've slowballed basically the judge, the higher court, everybody, and said, here's what I'm going to argue. By giving it to you directly, it makes it easier for us to address it at the higher court level. It also tells the judge exactly, if the judge got something wrong, Judge Herriford in this case, got something wrong, it tells them exactly what their face is going to be as far as getting things wrong in the judge's club when they say, this is what you got wrong. But by putting all that in there, it puts it all in one particular place in the record. The record is either the printed or the electronic version of what happened in this case. And they can go directly to it, argue it very easily for the higher court. And it's very easy for the higher court to then see what the lower court did or did not do, actions they took on a particular case. It makes things a lot smoother especially if you don't like what the previous attorney argued on the case you took over, and you want to clean up, is what we call it, clean up or clarify parts of the record for the higher court. So my bet is once they got the transcript or the parts of the transcript that they got and read, they then converted that to the appeal itself, all right, 90%, a heavy rough draft of the appeal, mainly the arguments, and then converted that appeal directly to the motion for a new trial. So if you have a copy of the motion for a new trial, I'd love to read it, but I bet to some degree, not all of it, but a large part of it is a preview of exactly what you're going to see at the appeal level. So that's the big picture. But let's talk about the specifics. So what I'm reading is that Superior Court Judge Herriford rejected arguments that from lawyers that Lanez that evidence was wrongly admitted at the trial he presided over. Okay, so Lanez lawyers asserted, among other things, that one, there was a post from his Instagram account that was improperly admitted to evidence. So this is the thing. That evidence against him is literally the least damning evidence, maybe the least important evidence in the entire trial. It could be disregarded and wouldn't make too much difference on if the jury would find him guilty or not guilty, quite frankly. But this is the thing for a piece of evidence like this, what you're looking for is something called foundation. So foundation is the word we use anytime we put in evidence, translated. Is that evidence what it purports to be? This is what I mean by that. When you see a picture, you have to ask the person who wants to lay the foundation or put the picture in the evidence, is it a picture? I mean, obviously it is, you're looking at it, but you still got to lay the foundation for it. Is it a picture? Did you see the place on the same day? And then does this picture show what you saw on the place on the day there were you? You don't have to be the one to take the picture. You just have to be able to say that the picture you see looks like that. In this situation, very simply, there's not a lot of foundation for the tweet. It's from Tory's account, but there's not, unless Tory testifies, there's no knowledge that Tory wrote the tweet. Did you see his fingers type it? Did you see him use voice to text? A judge can choose to let it in, but it's still up to the if the judge lets it in, it's up to the jury to decide what amount of credibility or what amount of credit they give to that statement. You're going to hear that as a recurring theme, not only through the trial, we talked about this in the previous videos, but also in the motion for a new trial is, what are you going to choose to believe, this or that? Like, are you going to get with this or are you going to get with that? Which one do you give credibility to? And in this case, and a lot of the people who are supporting Tory really want to give a lot of credibility to a lot of things the jury seem to not give credibility to. But as far as the tweet goes, the jury could have disregarded the tweet 100%, never seen the tweet, and I don't think the outcome would have been much different. So in that case, is the judge wrong about letting in the tweet? Probably not, because the jury can determine we don't believe that he even wrote it or that we do believe he wrote it, any of those type of things. But that's going to be the refrain of this particular case, is how much credit does a particular piece of evidence carry for this thing. Okay, so they said Megan's testimony that Lanez urged her not to go to police because he was on parole and then be in serious trouble, that was both untrue and an improper allowance of prior bad acts. So whether it's true or not doesn't matter because it's her testimony. She's allowed to testify, and it's the defense's job to cross-examine her to get the truth out. If they're saying it's not true, they have to cross-examine her on it. They're volunteering that. We're going to get back to why they're saying that the defense didn't do a good job in a minute. But the other part of that, which is improper, we talked about this in a prior video. Absolutely, it's introduction of a prior bad act, but is it improper? In this case, it very specifically is not. Under the rules, because he introduced it into the conversation, according to her testimony, because he introduced it into the conversation, and it clarifies either why she took actions, why he took actions, or why certain facts were made, because of these things, very clearly it would come into evidence if it's relevant in the fact, in this case, is that it's an admission of guilt if you consider that he's trying to pay her to not testify, right? So because of those things, absolutely this type of thing, it comes in. What's interesting about this, though, is what legitimate limiting instruction came in with this evidence. Anytime that you talk about prior bad acts, they almost always have to come with some type of what's called a limiting instruction. What is a limiting instruction, you're asking me? A limiting instruction is when a jury hears evidence, but they hear it for a different purpose besides deciding the ultimate issue of what happened. So when you hear evidence that is only to describe, for example, where someone was at a particular time or why they knew that person for a particular occasion, sometimes you can let that in, but tell the jury, hey, don't consider this evidence at all. You can only consider it for this particular purpose. Were they at this location at a particular time, not the ultimate event. So in this case, they would let it in for the particular purpose of what would it be? It'd be for trying to avoid him getting in trouble with probation. So they couldn't, he has a particular reason why they need to not testify, because the punishment for his case is going to be worse because he was on a previous case. So because of that, he has a higher reason to get them to not testify to a certain thing. Because he needs them to do that, he needs to pay them. But if you don't introduce the probation issue, none of that will make sense. So you have to say he needed to pay them as a way to stop him from getting a worse penalty for the probation case, if that makes sense. So that's what we're looking at as far as that piece of evidence. Yes, that's a prior bad act. Is there another way to let that in without explaining it? I don't know that there is. And then we also have to figure out what the limiting instruction is that they were given, and if that was broad enough to cover this particular act. So in this case, based on the balance of what I've heard, very clearly, I don't think it's even a question of whether it comes in or not. I haven't seen the limiting instruction, though, so that would be something that's interesting for me to actually read. But a jury's expected to be able to wall off their mind and use it only for a particular purpose. An appeals court or a judge can decide, because you didn't tell them to wall off their mind, or because you did, or the way you did, what you told them, what the purpose was, we're going to overturn the trial and give them a new trial because you gave that instruction wrong. And that's a more likely reason to get a new trial, honestly, than many of the reasons that we hear asking if the limiting instruction was wrong. Again, would that change the outcome in this case? I don't know specifically that it was. Oh, and finally, the other thing that I saw reported, and I guess there are 7 reasons, but I only saw 3 reported. So I'm just going to address the ones I see. If there's more, you have other things you want me to address, go ahead and put those in the comments. I have all the time in the world, obviously, so I can't sleep. So whatever, I might as well just answer them. So go ahead and give those to me. If it's something interesting or something interesting that I do want to come up with, I'm more than happy to respond to it. The third thing that was brought up in the newspaper article I read was that the DNA evidence the prosecutors used to argue Lanez was likely the shooter, was that Tory Lanez was the likely shooter, fell well short of industry standards. Okay, so anytime you want to get science into before the court, there's 2 steps you have to pass. One is there has to be some kind of standard that it's a science thing, and then it comes before the judge, and the judge decides, yeah, this is what they use. DNA evidence today, this is not 92, was it, with O.J. Simpson, where it was relatively new? DNA in today's day and age is used in all cases, all the time, every time. If they want to let it in a case like this, I don't even think that they needed it, quite frankly, or that it was interesting, quite frankly. But if they want to use it in a case like this, they could use DNA evidence because it's standard. Now, once you do that DNA evidence, then it shifts over to the defense to, again, take the credibility away from that. And by taking the credibility away from that through cross-examination, through their own experts, through whatever they can do to get the credibility away, lose the credibility of the DNA evidence. In this case, very clearly, it's not done. Now, again, this is going to go to the sub point, which I'm going to get to more towards the end. But this is why they're arguing about his prior attorneys. Because they're saying that the DNA was not up to standard, but also that there was not a valid cross-examination or a valid way. They didn't have the science, they didn't have the preparation in here to basically destroy the DNA expert's testimony from the prosecution. And if you're arguing a science case, if the case is about the science, which they're trying to turn this into, I don't know that it really is, but if that's what this would be, if the case is about the science and you don't have your own expert, you have to be able to be prepared to show that the expert they call on his own proves himself stupid. And that's always really hard off the top. It's not impossible. I mean, it happens all the time, but it's always really hard. And number two, just the threat of having your own expert is sometimes what you need for them to be honest about what's going on. And if he knows that you got this case at the last minute, I'm sort of predicting that you got this case at the last minute or there's any sort of thing going on, it's not that they're going to lie, but they may be a little bit more loose with their opinion, a little bit more confident. Their chest might stick out a little bit more. They may have a little bit more confidence in how they testify. And that's what juries take in to determine if what they're telling you is the truth or not the truth, quite frankly. So the confidence level is very, very important to how an expert witness testifies. Let's see what we got next. So again, what the judge did in this situation is the judge passed it off to the defense, which is honestly the right decision as far as this goes. But I'll tell you how that plays into the defense strategy, because that plays into the defense strategy. The idea that the defendant did not, the idea that the defense attorney did not properly cross-examine is the real defense strategy. So what's really going on here? This is what's important. Understand what the defense is doing. I'm yelling too loud. People are sleeping here. I shouldn't do it. But this is what the defense is doing. Did I shake that to it? This is what they're doing. This is why I'm so worked up about this. They're doing it right. This is what, as a defense attorney, the defense here is arguing it right. The running theme here is that his trial attorney did not do a good enough job because his previous attorney, who I believe is Sean Hawley, either left or didn't prepare enough to leave the trial. Of course, that's when my headphones go out. Of course, that's the moment my headphones go out. The running theme here is that the trial attorney didn't do enough of a good job because his previous attorney, Sean Hawley, either left or didn't prepare enough to leave George Megdassan, the trial attorney, without the time or means to prepare. Why? Because ineffective assistance of counsel is a reason why he would get a new trial. And a new trial is what he needs because nothing else is going to be a victory in this case. There's not a low enough sentence he's going to get, which he would consider a victory in this case. And it's not going to be dismissed out of hands because of some sort of, not like a Bill Cosby or but it's not going to be that kind of case because that's not what the evidence is. So he needs to get a new trial and then have the trial again to get his victory. That's the only thing that he can get here. And the way he's now trying to do it is by every time the judge is saying the defense attorney was not prepared enough or not capable enough in this particular context to do these particular cross-examination, this particular evidence argument, they're going to argue that the defense attorney was ineffective in that case, and for that reason, he deserves a new trial. Now, is that a basis to get a new trial? What you would have to do is we'd have to look at the specific law instead. Generally, it can be. Generally, it can be. If the reasons he made the decisions that he did were for trial tactics or because he chose to make those decisions, then no, you do not get a jury because of bad trial strategy. You do not get a new trial because of bad trial strategy. You do get a new trial, potentially, if the higher court determines that your attorney just was not capable or ineffective at helping you out. And that's a very high standard to say that an attorney, someone who passed the bar, someone who does it for a living, someone who's had good outcomes in other cases, was just unprepared. Although what they're setting up is not that the attorney himself is generally ineffective, but that I think what they're setting up is that he came into the case too late and that the other attorney did not prepare him, and he did not have time to prepare himself for this particular case, which honestly is the way to swim through these brooks, these eddies, this river. It's the only way to do it. They're not going to get it otherwise because he's a capable attorney with a long record who's been doing this before. The only way he's going to get it is that if he did not have enough time to get up to speed on this particular case. So many of the losses here cut two ways. It's bad that they did win their argument. That's for them, for the defense. It's bad that they did win their argument. That's correct. But by not winning, what they're able to do is suggest to both the trial judge and the appeals court that Tory's attorney at the time just simply was not prepared to run a trial either of this complexity or this amount of evidence or this ability. He was unable to do it, therefore ineffective, and therefore if you have an ineffective trial, that's not due process. In America, in 2023, we try to say everybody has a right to due process. And by having a right to due process, you have a right to have a proper defense. It's Fifth Amendment. You have a right to a defense attorney. You have a right to a proper defense. And if his attorney was not up to the level to give that proper defense, he gets a new trial. So in the sense, while they may be losing a battle, I think the strategy here for them is to win the war. I think that's really what they're trying to do, is win the war in this case. So the judge had two standards to hit. Then I'm going to finish. The judge had two standards to hit to decide if Tory deserved a new trial. Number one, whatever the grounds were, that a real issue that the court decided was decided wrongly. So he would have to say yes to that. And number two, that decision would, had it been decided correctly, would have impacted the trial to the degree that Tory could have been found not guilty in this case, or could have changed the judgment in this case. That's a pretty high standard, especially for him to find about himself. But the judge ruled from the bench and told them, in the end, the jury believed the prosecution's case beyond a reasonable doubt. So I can't believe I left this out the first time I went through just to hit this very clearly. What the judge is doing here is bulletproofing the appeal. What he's saying is it was decided strictly on credibility and strictly on what evidence they believed, not that there's a particular evidence that needed to be let in or out. By doing this, the one thing the appeals court will never touch, is should the jury have believed a particular witness, or did they believe a witness they shouldn't have believed? They're only going to decide based on what evidence should be let in or not let in, and did they rely on that evidence. So by saying what he's saying here is what he's saying is there's so much evidence that the jury believed that he did it so clearly. It has nothing to do with me putting on evidence that they didn't need to hear. It's important to do this. This is what judges do. It's called bulletproofing, or trying to protect their appeal to make sure they don't get overturned once it goes on appeal. What the newspaper article I read said, it called out Lanez's lawyers for not mentioning any of the other evidence that Lanez had when they focused on the perceived problems with some of the evidence. Now, quite frankly, that's not the defense attorney's job, is to focus on the good evidence, or the evidence that puts his client in jail. But it's a good point for the judge to make, to say, hey, even if these things you're saying decided the other way, even if they went the other way, he was going to be found guilty anyway, because that's the standard the judge has to hit, and that's what he has to decide in that direction in order to get the higher court to agree with Judge Herriford. Now, we think judges are independent or not worried about being overturned, things of that nature. The truth is, judges don't want to be overturned. It's basically your supervisor coming down and say, I know you think you know how to do your job. You don't know how to do your job. This is the way you're supposed to do your job. So judges are very cognizant about that. It's basically the one thing that could happen, they could do. One is being put in the newspaper with their face in the newspapers, having made a wrong decision that hurt or killed someone else, put the wrong person in jail, things of that nature. Number two is that a higher court in their jurisdiction comes down and says, hey, I know you decided it this way, but you don't know what you're doing. You've been a lawyer for this many years. You became a judge for this many years after. You got all that wrong. You should have balanced it this way, and we're going to do it right. So judges do take it very serious when they do get overturned, at least in my experience. So again, we're going to go with the refrain. It's very important. The jury can disregard any evidence they hear, if they so choose, and rely on any evidence they hear, if they so choose. This is why a lot of the narrations of the Lanez case, when you listen to people who support Lanez and people who don't, seem two totally separate cases, like they're describing two different things. All it is the people who thought he was guilty believe certain types of evidence, and the people who didn't thought he was guilty want you to believe other types of evidence. They say you should believe what Kelly, for example, says, or something else somebody says, or that the evidence should have come out this way. Where the people who believe Tory's guilty say, well, what I heard Meg say, which I believe, what I heard Kelsey say when it corroborates Meg, especially in the previous interview, that I believe, and what I saw Kelly testify to, that he knew what he was talking about, the eyewitness, the parts where he knew what he was saying or that he was paying attention, I believe these parts and don't believe these parts. And that's okay. That's the way the American justice systems work. If the American justice system's okay, which may or may not be true, that's the way it works. So it's okay that that's the way it is. And it looks like it's headed to appeal at this point. is headed to sentencing. So if there's something beneficial about sentencing, I'll make you another video. If you have questions about this video, it really does help me if you like and subscribe. If there's another topic you want me to talk about, I'd love to do that as well. I have all the time in the world, again, like I said. And hopefully I get the camera and mic and stuff set up better next time. We'll figure out how it is. But I wanted to definitely talk to you about this because I thought it was important that we get it out. If any other questions, thank you all very much always for listening. And I appreciate you guys paying attention because you could spend your time listening to any of these talking heads on the internet who don't know what they're talking about, whatever they're doing. And instead you let me talk to you at 4 a.m. while I'm on vacation with my family in my t-shirt with my little iPhone. So thank you guys very much. I appreciate your time. And let me know if I got everything wrong. Thanks. Bye.